espionage and interference is not successful in the UK.
Secretary of State Robertson.
Thank you, Mr. Speaker. Let me cut to the chase. It's standard practice for the CPS to inform the Attorney-General if a case of political significance that had required Attorney-General consent in the first place was likely to be dropped. We're told that the Attorney-General was informed this case was at risk, but the case had not formally been ended in August. Is this correct? Can the Solicitor General provide the exact date of that meeting? It would have been his duty to ask why it was at risk. That does not mean seeking to change the independent judgment of the CPS on whether to proceed, but it could and should have meant asking and ensuring more evidence was provided to the CPS at their request. It was abundantly clear that the CPS were asking for further evidence on the question of whether China posed a current threat to national security. So the Attorney-General and the government had a decision to make, whether to provide the evidence or not, even if they thought it was excessive to do so. The Attorney-General must have understood what was required. We are told he is an eminent lawyer. So what did he do the moment he knew? Who did he inform within government and when? Did he inform the Prime Minister or his office? Did he take any steps to ensure the evidence was provided? We know that on the 1st of September, the Director General of the AG's office attended a meeting at which the case was discussed. At this point, the case could still have been salvaged. At that meeting, did the Attorney General's office push for further evidence to be provided? Following that meeting, the Sunday Times has reported that the Attorney General's office was asked to speak to the CPS. Can the SG confirm whether anyone from the AGO spoke directly or indirectly to the CPS? Mr. Speaker, the AG knew the case was going to collapse in August. He knew what was required to save it. But unless she can provide a compelling account today, we must all conclude that the AG, on behalf of the government, chose not to provide it. He may not have killed the case, but he allowed it to die. There are examples in the recent past of AGs having the candour to come to the House and explain that the government and the prosecuting authorities have chosen to drop cases of the highest national security questions for diplomatic reasons. Will the SG today have the candour to do exactly the same with this case?
Today we've heard from the Shadow Justice Secretary yet more of the baseless smears which have characterised the Conservative Party's approach to this matter of such importance to this House and the whole nation. And he knows that the Attorney General will be giving evidence next week, as soon as Tuesday, to the Joint Committee on National Security Strategy. Like me, the Shadow Justice Secretary trained and practised in law, so he should know the importance of consistency when putting a case together. Yet his words today have only brought more confusion to their chaotic approach. First, they accused this government of political interference in this case without evidence. When this was disproven, they argued that we didn't interfere and that we should have interfered in an independent prosecution. So which is it? Mr. Speaker, their approach has only served to distract from their own failings and, frankly, does a disservice to the history and heritage of their party. I respectfully remind the House that part of the reasons we find ourselves in this situation is because the Conservative Party spent their years in government fighting amongst themselves and not fixing glaring holes in our national security laws. The charges in this case were brought under the Official Secrets Act.
Mr. General, when you get